outset, congratulations to the team of organizers and Madam Sharda for taking this initiative and holding series of webinars on very interesting and contemporary subjects. And once again, thank you for giving this opportunity. Well, without much ado, let me straight go to the topic, but a few things before I start. What I wanted to discuss in breakout room, I may discuss here for the sake of understanding how we go about. As you know, introducing the law of contract for business transactions is a Herculean task. I was really, wondering where to start, where to end, and at what details I should go. Should I go in details and make it incomplete? Should I give a whole view without getting into details and making no sense of it? Was the difficulty that I faced. However, I have taken call to go in necessary details wherever possible, keeping in mind not the law student, not the legal academician, keeping in mind a businessman. How much of law of contract a businessman must know? What are the important things a businessman must pay attention to? So keeping that in mind, I'll be going ahead and excuse me for deciding the time for myself, which I would have bargained with Madam Sharda in breakout room. Since we could not get an opportunity to discuss with you, I would request you to allow me 1 hour, 10 minutes time.
Yeah,
I
sir,
will
you
set
can.
my as I try to tell you, it's the bird's eye view that I am trying to give and not the holistic picture of the whole law. Nevertheless, wherever the participants get doubt, I, for paucity of time only, prefer to have the questions at the end. If at all it is necessary, you can unmute and ask question, or I leave it to the organizers. Probably organizers are trying to seek the questions in chat box and
Yes,
put them together and throwing it at the end. I believe that would
yes,
be
yes.
a fantastic thing to do. We will definitely have some Q&A session. Keep posing your questions in the Q&A box. Well, I think with that, let me quickly move on to my topic. As I said, hope you are all able to see the slides. Can you see my slides? Okay.
Yes, sir.
Yes, sir, we can see.
Well, thank you. Uh, I did confine to the topic that you have allotted to me without making any alteration in the topic, and rather I tried to alter my talk to match the topic that you have given. So it's a law of contract and its role in business transactions. What role the law of contract has got to play in business transactions? How much a law of contract a businessman must know, why he should know, and what are the benefits he will have by knowing that is what I'm trying to trace about. As I'm going to trace about, as I told you already, it's only the bird's eye view I'm trying to give you. And I'm sure, even though it's a bird's eye view that I'll be trying to give you, I'm hopeful and I'm sure that I'll be able to elicit interest in the subject. I'll be able to convince and give some insight into the subject. With that fond hope, let me start and go ahead with a few initial remarks. Well, why contracts? Why contracts are important? Why contracts are important and why the businessman to conduct his business transactions must know contracts. Some light on this point. To start with, there is, okay. To start with, let me start with this point, basic assumption that human existence on earth is possible only through contract. Which contract we call the social contract theory, starting from Aristotle, Socrates, Rousseau, Hobbes, and so on. It is that social contract theory that kept us together today and our agreement with the state to obey the laws and state taking best care of this matter is at the root of our human existence is what I believe strongly. So the point to be driven home is not only the business transactions, even the human existence on earth has relation with contract, which philosophers like Hobbes, Locke, Socrates, and the recent philosophers like John Rawls and Kant have propounded and agreed that without social contract theory, without social contract, human existence on earth is impossible. Well, that apart, are we into contracts in our day-to-day life? Excuse me, there is a little disturbance for me. Give me a second. Well, sorry for that interruption. Are the contracts strange? Are the contracts universal? Needless to tell you, all of us are aware that the contracts are endemic. There is no place, there is no time, there is no day when we do not make contract. They are omnipresent in day-to-day life, in all our activities. If you have reached your college, you have already completed one contract. If you had the public transport facility. If you have installed Zoom app, you're already into a contract, whatnot. So the point to be driven home is contracts are endemic and omnipresent in day-to-day life of all, leave alone whether you are a businessman or not. That being the case, coming to business transaction, unlike a social interaction, if you as a retail merchant had agreed to sell a quantity of rice to me and deliver it at my home is one thing. And you had agreed to be at my home for a dinner in this evening is another thing. The second thing is an informal transaction, whereas the first is formal in nature. So all business transactions are formal in nature. So what? If all business transactions are formal in nature, the business transactions and the key to successful business transaction lies in the contract. Contract is the starting point of any business transaction. Without contract, there is no business. Hence, it becomes necessary to know what is contract, right? And contracts, it's a wrong belief that we must make a contract, we must reduce into contract so that when something goes wrong, it will be better for us to resolve the dispute. That's a wrong thinking, rather, I believe. Contracts are needed not only for resolving differences if they arise, but also to serve as the instruction manual or the roadmap for business relationship to work well. If I am in business relation with my customer, with my supplier, with my employees, and many, if this business relation has to last long, if this business relation has to be fruitful, peaceful, and amicable, that also requires for all of us to have a roadmap and go accordingly. Contract serves as instruction manual for the parties involved in the contract. That would make the business relationship possible and amicable. That is at the root of growth of all parties involved in that business transaction. So the point to be driven home is do not read contract as an essential thing to resolve the disputes if exist. It is essential even for the purpose of maintenance of proper relation between the parties involved in business transaction, ultimately leading to the growth of business, right? Well, hope that makes sense. And the next point I wanted to talk to you is success of business lies in a well-conducted contract management. Having said business transaction is formal one, key to business transaction lies in contract. Contract is the starting point of business transaction. If you want to have a successful business model, you must have a system of well conducted, I mean well administered, well handled contract management. Contract management, in fact, is very important for the variety of reasons that I already stated. And we must not pay least attention to it. We must pay best attention to it rather. But what are we doing? Are we paying most attention to this contract management? Unfortunately, to tell you, research reveals that less than 10% of the concerned read the contract. Look at it. I told you already, contract is at the root of successful business. Contract is the key to successful business, but the parties to the contract, they leave it to the others. Others will negotiate, others will draft. The parties who have to adhere to the contract, parties who have to perform their obligations in the contract, unfortunately don't get time to read, don't understand that it is they who should read and understand and make sure that what T's and C's are there, what terms and conditions are there. They forget to do that. As a result, a business organization obviously suffers and incurs loss. So because of that decelerated attention to the T's and C's of contract by the concerned parties, unfortunately, contracts are least protected assets of business organization. If you find it interesting, please pay attention to the words that I have been using. I'm trying to call contracts are assets rather of the business organization, which are least protected. Contract is the key to success of the business. If you have not paid utmost attention to it, you have spoiled it. As a result, contracts are least protected assets of business organization. If you have not handled the contracts well, you have lost the important asset of your business is what you want to understand, what I want you to understand. And the poor contract management, which I am alleging, of course, through the research that I quoted, which says only 10% of the concerned parties read the contract, and they get to realize only after the problem arises. This poor contract management and no attention to the contract management often leads to the loss of capital and revenue. It affects profits. It jeopardizes the customer relation and ultimately the growth of business itself. So I think these were few of the points that I feel would justify why contracts are necessary. A, for our day-to-day life. B, for persons involved in business transaction. Well, if I made that point and proved why it's necessary, let me go ahead and tell you a few of the important components this commercial contract management policy should have. If you can gather now, I'm trying to come and tell you every business organization, small or big, must have, along with other things, what is called a commercial contract management policy, CCPM, I call it, so that you will be able to know that it is important. You will pay attention, you will read terms, you will negotiate well, so that it will lead to the growing business of yours. As I said in the previous slide, growing business of yours needs the attention to be paid to contract management. So if at all one is convinced that a small businessman or big businessman, he must have what is called CCPM. What this CCPM would include? What are the important components? I would say there are at least three basic important components of this CCPM. If it's a matter of interest, let me go ahead and tell you what are these three important components. Contract negotiation. Who will not negotiate the contract? Everybody will negotiate the contract. But probably where we miss out is we misunderstand negotiation to mere bargaining. So I would like to suggest, when you pay utmost attention to contract negotiation, do not think that contract negotiation is mere bargaining. It's beyond that. What is this? What is there beyond the bargaining? Probably contemplating the future occurrences and foreseeability is very important. Today, I am making contract as the things exist today. Who has seen tomorrow? How the things will change tomorrow? Try to contemplate, try to foresee how the things will change tomorrow. Under the changed circumstances, whether you are going to be a beneficiary under this contract, whether you are going to be affected by this contract, then contemplate and insert the clauses, bargain for it. If you have agreed to sell 100 bags of cotton, 100 bales of cotton to a merchant, you have agreed and you have obtained loan or received some money from him, shouldn't you include a clause like, if my crop is affected by insects and some diseases, if I'm not able to pay, I should be excused? Shouldn't you have that clause? So you must have foreseeability as well. So I'll not delve much into this beyond this point. So the point to be remembered is, one must pay utmost attention to contract negotiation. In contract negotiation, apart from best bargain, you must also concentrate on contemplating the future occurrences and trying to protect your interests under the future occurrences which are contingent. And then, very important thing is, however beautifully you must have negotiated the contract, if reducing the terms and conditions of the contract goes into the wrong hand, the language, as all of you know already, is ambiguous. Nobody is blessed with the prophetic ability to draft your contract without lapses. Yet utmost attention has to be paid by the draftsman who goes to draft your contract to include the desires of both parties, right? So pay utmost attention to this. Well negotiated contract may well be destroyed by a poor drafting. Use of unambiguous language and the well punctuated draft is the key. Remember this. Punctuation forms part and parcel of the language itself. The punctuations, those of you even interest in interpretation would understand this. Punctuations play a vital role in giving meaning to the language. So let me stop at this stage saying contract drafting is another essential thing which a businessman has to keep in mind as an important component of his CCPM. Last but not the least, which I would be talking to you today. The third component is legal compliance. The agreement I am entering into, the contract I am making, is that enforceable in the eyes of law? You must see that. If you make a contract or if you make an agreement, I'll come and tell you in course of time what's the difference between agreement and contract. If you make an agreement, if it is not enforceable in the court of law, you are gone. Your business is gone. So you also, this is where you need to know law of contract, a bit of law of contract, and make sure that apart from best negotiation, apart from best drafting, you have got to know some basic rules of Indian Contract Act to make sure to yourself that the agreement you are making is enforceable in the eyes of law. And that's where I would be trying to give some bird's eye view of the basic principles of law of contract in this lecture, right? So why you need to know is the agreements that you make in the course of your business transaction, they're all not, I mean, all of them are not enforceable, though all enforceable contracts are agreements. Hence, you have got to know the law of contract, which makes your agreement enforceable so that you can exercise your rights and obligations under the contract, right? Well, uh, before I take you to these glimpses of contract law, a quick reference to, a quick look at the bizarre situations where the law can help and protect you. Otherwise, your business may not be protected. I'll be quickly trying to give about 4 such instances that you wonder about. Look at the first one quickly. For paucity of time, I may be going a little fast. You may kindly try to keep the pace. There is no other alternative. All right. Uh, it's called the best liar story. Some of the teachers must have come across this. It's in fact, a real incident that happened in US in 2013. Quickly, let me tell you what has happened in this instant case. Rather, a lawyer purchased a box of very rare and expensive cigarettes. And it's common practice in US, some of you must be knowing, they insure anything and everything apart from life and motor vehicles. So they did insure. This lawyer insured the costly cigars he bought along with, and insurance covered that, it is against fire. If these cigarettes are burnt in fire, insurance company will pay so much of money is what they have agreed. Is that okay? And then after having procured the premium, after having procured the policy, the lawyer, within a month, he smoked all the costly, expensive cigarettes. And then he filed a claim against the insurance company saying, the costly, expensive cigars which I have insured with you by paying so much of premium have now been burnt by fire. You did cover them to compensate me against fire. The clauses are met. Now you have to pay me compensation. Might look funny, but look what has happened. In his claim, the lawyer stated cigars were lost in a series of small fires. It's a matter of fact. It's a matter of fact that these insured cigars are lost in series of small fires. So the contractual term is met. You have got to pay me compensation. The insurance company, of course, obviously refused to pay, citing the obvious reason that man had consumed the cigars. This man who insured had consumed the cigars in the normal fashion. Apart from that argument, for your surprise, yet the lawyer sued and won against the insurance company. You must be wondering, how could that happen? If you are wondering, look at the observation by the judge. Judge said, the claim was of course frivolous. That means silly. Nevertheless, he stated that the lawyer held a policy from the insurance company in which it had warranted that the cigars were insurable and also guaranteed that it would insure them against fire without defining what is considered to be unacceptable fire. What is unacceptable fire is you putting fire to your own insured good is unacceptable. But you have not stated it expressly in the contract. All that you stated is we will pay you if your cigars are burnt by fire. So the court too agreed, not way back in 2013, and said, company is obligated to pay the claim. Look at one drafting error by a lawyer for the insurance company, who did not say cigars burnt by accidental fire. He simply said cigars burnt by fire. One missing of word, that is accidental, caused so much loss to the insurance company. So the judge said so, continued part of it. Insurance company left with no option. Insurance company thought it is wise to avoid costly appeal and pay it off to the lawyer. Witty and wise lawyer. Insurance company ended up paying $15,000 to the lawyer. The best part comes now. The best part is this. After the lawyer encashed the check issued by the insurance company had filed a complaint against him for an offense called arson. Arson is an offense, even in our IPC, where a person deliberately puts fire to some property in order to cause loss to the other. On this, for this offense, complaint was filed, he was arrested, and ultimately again the court, with his own insurance claim and testimony from the previous case being used against him, the lawyer was convicted of intentionally burning his insured property and was sentenced to 24 months in jail and 24,000 rupee of fine. Of course, the story was interesting. And you might understand the lawyer was taught a best lesson by the insurance company. The reason why I took this story is to emphasize the point that one drafting error has become so costly. Not reading it by the insurance company has caused loss. So you may recall those expressions I said. Unless you pay attention to your contract, you are losing a very valuable asset of your company. Okay, so the point to be driven home is paying attention to the contract and paying attention to the draft is very important. Having said that, let me quickly take you through some more instances. Suppose you had agreed to supply a quantity of ready-made garment. You are a manufacturer of ready-made garment. You had agreed to supply a quantity of ready-made garment to the seller, retail seller. You had to deliver by 31st July 2020. You're able to imagine now. As a result of widespread COVID-19 pandemic, consequent lockdown for some time, reverse migration of workers, etc., manufacturing is not happening. You are unable to supply the promised quantity of garment. Retailer hold you liable for compensation. What will you do? You cannot please impossibility of performance. Had you inserted clauses in your contract contemplating that if such a situation ever becomes, if such a situation ever comes into existence, you could have stated you should be excused for delayed supply, you should be given extra time, which we call in law as force majeure clause. So contemplating at the time of negotiating the contract become important is the point I want to drive home with this example. Similar example, quickly. Similar one, please go through. You drew a loan of 10,000 rupees from X, promising to repay at the end of 3 years with agreed rate of interest. The amount become payable during COVID-19 pandemic days. Imagine whatever period after March and till now. You have lost your job in the process and suffered loss of income. As a result, not able to pay the loan along with interest, though it became due. X compels you to pay. He has his own reasons too. Again, had you contemplated and inserted some force majeure clause, it would have been possible for you to get the additional time applying that force majeure clause. Let me not delve into the force majeure clause. All that I would like to tell you with these two examples is, at the time of negotiating, contemplate future occurrences and try to answer those future occurrences. Though you agree to do something, if something happens in future that will delay your performance, insert some clause so that you will be excused. That is the attention needs to be paid. I think just two more I have examples before I take you through the law relating to this. Quickly look at this instance. Suppose you had left your car for servicing at a service station, as all of us leave our cars for servicing station and put our signatures on the paper that is produced before us without even reading it. At times it looks like it's better to put our thumb impression than putting our signature, as we go to put our signature without even reading them. So you were issued on delivering your car to the service station, you were issued with an invoice which contained terms and conditions. One of them read, the company is not liable for the loss of car by fire. The same example, you can relate it to a liar story. Due to negligent act of serviceman, when the servicing was going on, there occurred a fire incident. Your car along with others' car is burnt in the incident. You claim compensation from the company show it to your face that you have agreed in writing that if your car is ever burnt by fire, company is not liable to compensate. Again, the same question. What you must agree or you must have agreed is for accidental fire. Here is a case, there is no accidental fire. If the language is so badly worded, if there is no adjective accidental, if there was only the clause that you are not liable, company is not liable if the car is burnt by fire, your case is gone. So this is again to emphasize how important is the drafting. Last but not the least, that will take us to the precise point. Suppose you agree to buy a car from a minor, either without knowing that he is a minor or having reasons to believe that he is an adult, or the minor himself goes ahead and claims himself to be an adult, maybe produces a certificate as well. You have advanced some money upon his agreement that he will deliver the car on the last day of this month. Later, the minor refuses to sell the car. Can you compel him to deliver the car? The answer in law is no, because the agreement you have entered into is void ab initio. Can you compel him to return the money paid as advance to him? It's doubtful. It's doubtful because though minor's agreement is void, the law says so long as the goods that you gave to him under void agreement are with him, he is under a liability to return them. In the instant case, what you are given is not money, in the instant case, what you are given is not good, but money. Money is not traceable. Probably your claim for refund of money also fails. What else you can do? Probably you may try your option under liability of the minor for the necessaries supplied by somebody if you can prove that it was the case of necessaries, right? So that takes you to know little about law. So whether minor's agreement is valid or void. If it is void agreement, is it enforceable? It's not enforceable. If it is not enforceable, is it that minor is excused of all obligation or has he got some obligation? Whether the adult who entered into agreement with minor will go without remedy or are there still some remedies for him is the question of law, right? So a business transaction, for a successful business transaction, one needs to know little of law as well. I think that takes you to the precise point that one must know basics of contract law for a yielding business transaction. For a successful business transaction, you need to know some basics of contract law. I'm wondering, I'm left with 40 minutes time and how much of it I would be able to cover. As I told you already, some of them need detailed attention. Some of them may not need much attention. So if I go faster with respect to few of the aspects, I believe they deserve less attention. However, if you get any doubt, you can certainly ask your questions at the end. Can somebody make me comfortable by saying, is the pace okay or you want me to slow down?
Very nice, sir. Wonderful response.
Pace okay?
Yes, sir, it is okay.
Yes, sir. Yes,
Go
sir.
ahead.
Because I have got to do a lot of job. Okay. Well, a few obvious things also I have to be telling because, it is said and very, very well said. Sometimes it's better to explain the obvious than to elucidate the obscure. So some of the obvious things are these. What is a contract? The first thing you must know is every agreement is not a contract. Only that agreement which is enforceable in law is a contract. That is the minimum thing a businessman must know. Every agreement is not contract. That's why we say all agreements are not contracts, but all contracts are nevertheless agreements. So remember, businessman, all agreements are not contracts. It's not enough if there is proposal and acceptance. If there is proposal and acceptance, it results in agreement. You have got to check whether that agreement is enforceable in the eyes of law. Only then you are protected under that contract. Otherwise, you will lose in your business. So essentials, as I said already, first of all, there must be an agreement. Agreement is the result of proposal and acceptance. I'll be taking you through a few points about what is in the eyes of law called proposal, what is in the eyes of law called acceptance. If proposal and acceptance results in an agreement, as you know already, an agreement, mere agreement is not enforceable. Further, Section 10 of Indian Contract Act, of course, you may not be concerned with the number. Another provision of Indian Contract Act say this agreement must have been entered into by the parties with their free consent. And the parties who have entered into this agreement must have the capacity to enter into agreement. What is the capacity? I will be talking to you. Then this agreement must be for consideration, not without consideration, and that consideration shall be lawful. And the object for which you enter into agreement must be lawful in the eyes of law. And then the agreement that you have made must not belong to any of the categories of agreements declared to be void under this act. You need not wonder what are those agreements declared to be void under this act, because I will be covering them in the course of my talk. And then sometimes, though Section 2H, if you see, all that it says is an agreement enforceable by law is contract. Where is the requirement that an agreement has to be in writing? In other words, in the eyes of law, according to law of contract, an oral contract is perfectly valid, enforceable contract. Please remember, if you can prove it. However, sometimes, apart from Indian Contract Act, some legal formalities may be there. Like you must register your agreement. Your agreement must be in writing. Your agreement must be attested by witnesses. Your agreement must bear the signature of both parties to the agreement, kind of things. If there is any other law preaching such a thing, you have to comply that as well. Otherwise, your agreement remains a mere agreement and it does not attain the status of contract. You will not seek the assistance of courts if it does not mature into a contract. So you have got to know these aspects. Of course, there is this interesting aspect called intention to contract. You have got to establish that it was a formal business transaction than a social arrangement, like the one I said in the beginning, that you agreeing to sell a quantity of rice to me delivered at my home is a formal business transaction. You agreeing to be at my home in the evening for dinner is an informal social transaction, right? So in the first case, there is an intention to contract. In the second case, there is not. This also needs to be shown at times to the court. Well, I think, and the last one being certainty and possibility of performance. If you have entered into an agreement, the performance of the promise in that agreement is impossible. Again, the agreement remains agreement. It does not become contract, right? Well, with this brief idea about what is contract and what are the essentials in order an agreement to become contract, let me go ahead and quickly tell you what these terms mean. We said there shall be a proposal. A proposal means when I express to do something with a view to get the assent of yours. I would like to sell my motor car to you for rupees 5 lakh. What have I done? I expressed my intention to do something, that is giving away my motor car to you. Why did I say so? To get your assent. What do you want to know? When I did it, I have made a proposal, right? And this proposal may be express or implied most of the times. If you remember, I started my lecture saying we are into contracts all the time, every day in our day-to-day life. You get into a public transport. Did you ever make an express oral offer to the conductor there? You did not. The very fact that you got into a public transport, your conduct shows you have made a proposal that you will be paying for taking you to the place of destination, desired destination, isn't it? So a proposal may be express or implied, and a proposal gets complete when it is communicated to the other party comes to know of it. Of course, there must be an intention to contract. With respect to proposal, proposals are so made that they may be made in public, which we call general offer. When there is a general offer can be accepted without the proposer knowing the offeree, right? I think let me not get into those details. This one important thing you may try to understand. This proposal and invitation to proposal are often confused, and the parties are likely to misunderstand the essence of it and either fail in their contract or wrongly be benefited in their contract. In our day-to-day lives, as I said, often we enter into contractual relationship. Some of them seemingly are proposals, they are indeed not proposals. Let me quickly take a few examples. You go to a hotel and the menu is placed before you with the items that they agree to serve you for the price that is mentioned against the items. You go to a bookstore or what you call a supermarket. The price tag is fixed. The price tag is put on each of the item, each book or each of the item. When you take the book to the manager, can the manager reject? When you take the book to the manager or the cashier, offer to pay for the book, are you making proposal? Are you accepting? It looks like the fact that things are kept for sale, price tag was put. It looks like the owner of the shop there made a proposal. But in fact, it is not. He invites you to buy. He invites you to buy the product for the stated price. When you pick that book, express your intention to pay the fixed price, then you are not accepting the proposal, you are making the proposal. If you are making the proposal, the cashier, for the reasons he knew, he may reject as well, because what he has made is invitation to proposal and not proposal itself. So proposal often needs to be distinguished with this invitation to treat. Well, I think if it is not clear, I can take some question at the end. Going further, in order a proposal to mature into agreement, there must be acceptance. When proposal is made to me expressing intention to do something with a view to get my assent, if I say yes to you, if I agree to you, your proposal made to me is said to be accepted, right? In other words, to put it in simple, acceptance is, proposal accepted becomes the acceptance. It's a promise. Accepted proposal. I'm sorry, it's called accepted proposal. All right. So, like proposal, acceptance too could be express or implied. You can relate the same example. When you get into your public transport, neither you make a proposal nor the conductor says yes for your proposal. You enter into the public transport like public bus. You conductor keeps quiet, allows you enter, that is his implied acceptance. Right? Well, like in proposal, acceptance has to be communicated. If I express my intention to sell my motor car to you for ₹5 lakh, you feel supremely happy and you are on your toes to give your acceptance, but you have not conveyed it to me. That's no acceptance. In other words, there must be communication of acceptance. It must be manifested. Okay. So you must express it. There must be manifestation, external manifestation. Communication of acceptance must be to the offerer. I make an offer to you. You express your intention to accept my offer with someone else. That's not acceptance. You must have communicated it to me. Communication of acceptance by the offeree. You have shared your intention of accepting my offer to your friend. Your friend communicates it to me. That's no offer. Simple point, right? Acceptance may be complete by fulfilling conditions of the offer. As I was telling you a while ago, general offers. If my dog is missing, I make a general offer. I publish in newspapers or I distribute pamphlets saying my dog with so many features is missing. Anybody finds it and brings it home, I'll pay 10,000 rupees. It's a general offer I have made. You need not communicate the acceptance to me. Your conduct of finding the missing dog and returning it to me itself amounts to acceptance, is the point. There is some law that is developed with regard to mode of communication. How should I be communicating my acceptance? Generally, if the proposer has prescribed the mode of communication, I write a mail to you making my proposal. In the same mail, I write, kindly communicate your acceptance within 3 days by written mail. Instead of communicating your acceptance by written mail, you will telephone me and say you will accept. Is that valid? Law provides so long as the proposer prescribed the mode, prescribed mode has to be adopted. If the proposer has not prescribed the mode, then any reasonable mode is permitted, is what the law states, and we must be aware of that. There is also a law developing on this point. Once I communicate my acceptance, can I revoke it, or at what time the contract happens? Law permits at least the acceptor to revoke his acceptance before the acceptance reaches the proposer. Please follow my words. Law permits at least the acceptor, that is offering, to revoke his acceptance, to withdraw his acceptance before the acceptance reaches the proposer. So that's possible, right? With respect to this unilateral, or I mean, with respect to this acceptance, okay. Excuse me. Acceptance is must for a proposal to become agreement, first of all. When acceptance is given, acceptance generally has to be given out of free will. But in our day-to-day lives, as I said already, as we enter into so many contracts, we hardly negotiate our contracts, nor draft our contracts, nor we know the terms and conditions of our contracts. Such contracts which you make in your day-to-day lives, neither you negotiate them, nor you draft them, nor you ever know them. Is it surprising for you? It shouldn't be. Let me take the same example. If you have used the public transport to commute from your home to your college, did you bargain for the price? Is it determined in advance, except the auto rickshaw where you may bargain? If you have used the KSRTC bus, did you bargain for the price? No. Did you know? At times may not. Did you know the term subject to which you are carried? If there is breakdown of engine on the way, there may be a term that is printed on the back or front, wherever, of the ticket, which must be stating that for such a thing, company is not responsible. Amount paid is not refunded. So that's why I was telling you, you can relate it to many of such examples. You go to a courier guy and give the parcel. You go to a cinema theater. You go and park your motor car. You go and park your motor car of about 20 lakh rupee. Mercilessly, the person in charge there would ask for your key, and he will pass a token to you. The token will say, we are not responsible for any damage that happens to you while the car is parked with us. Did you bargain for that? Did you know that? Did you draft it? Never. Such kind of contracts where only one party decides what shall be the terms of the contract. The other party never negotiates, never knows. If he knows, he cannot do anything about it. Such kind of contracts are called standard form contracts or unilateral contracts. Since only one party decides the contracts, the business community made best use of the opportunity and tried to have all draconian terms, putting the other party in risk. So the courts have evolved certain protective devices. A businessman must be aware that it is wrong to have any and every kind of draconian term in your contractual document, because that will not protect you. In fact, the courts have evolved what are called protective devices. I'll quickly take you through those protective devices. Even though you entered into contract with a businessman and businessman issued you a contractual document which contain terms, those terms may not be applicable. Those terms may not form part and parcel of contract, provided the businessman had given you reasonable notice of those unreasonable terms. And nextly, even if you have signed the contract, there were some oral assurances given to you which you can prove of. Even though you have signed the contract, you can get rid of draconian terms in that written contract. If the terms are unusual terms notice has to be given more specifically to you. Like you send a parcel from Hubli through VRL to Bangalore. At at the designated place I have to receive them, and the VRL has a term. Since we are located in a very thickly populated area like Majestic area, you must collect the consignment within 3 days. If you do not collect consignment within 3 days, rupees 500 of demurrage is going to be charged every day. The value of parcel itself is less than 500. If that term exists, that's an unusual term. Explicit notice has to be given about it. Contemporaneous notice. You cannot give notice after the contract is entered into. At the time of entering into contract, give notice. Theory of fundamental breach. Every contract will have a core of it, core of the obligation. If I have contracted to deliver this lecture to you, how convincingly I deliver this lecture to you may be a matter of debate. I'll shut my screen and go off, may not be a matter of debate. There is my core obligation to deliver the lecture itself, isn't it? So every contract will have a core obligation. If I had said, for whatever reason, if I happen to shut my lecture at any point of time, I am not responsible for anything, and you have agreed for it. Yet you can sue me for the reason, by giving notice or by putting it as term and condition, fundamental obligation cannot be taken off, right? Well, the courts would strictly construe in favor of weaker party. We are going to catch hold of you in tort, if not in contract. And if there are unreasonable terms, again, on the ground of unreasonable terms, you may get rid of those unreasonable terms. So the sum and substance of the message to be conveyed through this slide is this: that businessmen, because of the tendency among the other parties, especially customers, businessman has a tendency to include all draconian terms in the contract. Beware, those draconian terms really do not protect you. The courts go to the protection of weaker party, the consumers. Of course, now the Consumer Protection Act and other legislations hold the field. This piece of law I'm talking about, I would call it the first piece of consumer protection law indeed, right? Well, with that, a quick look at with whom you have to make contract, with whom you shall not. You shall not make contract with minor, You shall not contract with persons of unsound mind. You shall also not make contract with persons disqualified by law. Minor is one who has not attained the age of 18 years. Person of unsound mind is one who is not able to understand the transaction, nature of the very transaction, and its consequences upon his interests. However, don't uh, understand that the person of unsound mind means lunatic, not necessarily. If a person is not able to understand the consequence of what he is doing, for that time he is called person of unsound mind. Similarly, persons like alien enemy, insolvent, more importantly, insolvent, companies with restricted authority to make contract are all disqualified to make contract. Be careful when you are making contract with them. And then there shall be a consideration. I'll not delve much into these details. I'll try to give you a quick overview of this. In law, an agreement without consideration is not valid. It's not enforceable. Then what is consideration? Consideration is, generally speaking, it is something in written. We call it quid pro quo. And that quid pro quo or something in written must be valuable in the eyes of law. It must move at the desire of the promisor. It may be by promisee or anyone else. It may be past, present, future. It need not be adequate. This is important point. Please remember. Consideration is, if I agree to sell my motor car to you, my consideration is the money you give me. Your consideration is the motor car I give you. So consideration exists for both of us in the example I took. So consideration is something of value. Consideration, if it is inadequate, that will not vitiate the contract. Contract would yet be valid. Okay. Well, however, no consideration, no contract rule admits some exceptions, like if it is contract out of natural love and affection, promise to compensate for services, time bar debt, completed gifts, agency, etc. However, you must remember in 5 circumstances, without consideration, there can be a valid contract, and that can be a matter for discussion again. All right. Well, I was hurrying to move to this hard part of the aspect. That is free consent of parties. Consent is when both of us agree on the same thing in the same sense. We say there is consensus ad idem in law. That means both parties must be on the same page. I keep something in mind, you have kept something else in mind. We thought we have kept the same thing in mind and agreed. Then there is no consent at all, right? So both parties must be on the same page. There must be consensus ad idem. They must agree upon the same thing in the same sense. Having ensured that there is consent of this type, the consent has to be further free. When consent is free, consent is said to be free if it is not caused by these 5 aspects. I have not forced the other person to give consent, called coercion in law. I have not made misuse of my authority against the other who stands weak in position compared to me. There is no undue influence. The consent I obtained is not by employing undue influence. Undue influence is said to be employed when one party is strong, the other party is weak, and one party is in a position to obtain consent by undue means. Undue influence is likely to take place. Sometimes consent is said to be not free for the reason the proposer made misrepresentation. I have said my motor car is 2005 make, whereas it is 2000 make. I have made a factual misrepresentation. You gave consent believing that the motor car was 2005 make, whereas it was 2000 make. Again, the consent is said to be not free. There is a thin line of difference between misrepresentation and fraud. The similarity is in both cases, false representation is made. In misrepresentation, false statement is made innocently. In fraud, false statement is made wantedly, intentionally. And if the parties are mistaken about material aspect of the contract, again, the consent of the parties is not said to be free. Well, what happens if the consent of the parties is not free? Sometimes the agreement does not mature into contract at all. Sometimes the agreement becomes a contract voidable. If there is a coercion, undue influence, misrepresentation, or fraud that caused the consent, the other party against whom these things are played may either validate the contract or avoid the contract at their option. Whereas if there is a mistake with respect to the material fact, which amounts to no consent at all, the contract may become void. Right? Well, I think with that little idea about consent of parties, which is hard part indeed. The other important aspect that may become material for a businessman is to make sure that the object for which they are making the contract is lawful. Because that is one of the reasons makes your agreement to mature into contract. And that is called legality of object. Object of the agreement or the consideration is said to be law provided it is not forbidden by law. Right? If anything is forbidden by law, object of the agreement is to carry out such thing. The agreement does not mature into contract because it is forbidden by law. It may not be forbidden by law, but it will defeat the provision of any law indirectly. Again, agreement will not mature into contract. It may not be forbidden by law. Object may not be forbidden by law. It may not even defeat the provision of law, but it is fraudulent. X and Y agree to do something by which they want to cause loss to Z. So, though it's lawful, it's not forbidden. It is to commit fraud upon others. As a result, object is unlawful. If it involves injury to person or property, one hires the other to go and set fire to other's property. One hires the other to go and break other person's leg. That involves injury to person or property. Hence, the object is unlawful. And this last but very important is, even though the consideration or object of your agreement is not forbidden by law, it will not defeat the provision of any law, it's not fraudulent, it does not involve any injury to person or property, but the court comes to the conclusion that the object of the act in the eyes of the courts is immoral or opposed to public policy, then also the court may declare such agreement to be void. Right? Well, having learnt a little about that aspect, legality of object, let me quickly take you through these categories of void agreements. I was telling you in the beginning, this act lists as many as 9 agreements and declares them expressly void. Make sure that your agreement does not fall under any of the categories of the list. First one, as you see, as I spoke already, where the object or consideration of the agreement is unlawful, you will not get any rights under such contract, such agreement. It's void. Even if it is partly unlawful, you have to do away with that. Without consideration, no, it does not mature into contract. Since the law encourages freedom of marriage, if the agreement in some way goes to restrain the freedom of marriage, you shall not marry so and so, you shall marry so and so, you shall not marry for some time, and so on. You can imagine of the situations. So any agreement that is in restraint of marriage is void. That may not be material. Now, what is material and important is maybe these two things for a businessman: restraint of trade and restraint of legal proceedings. Be careful. Agreements in restraint of trade are void, though it admits of some exceptions. You may enter into agreement which has the effect of withdrawing the freedom of trade of another person. That agreement may fail. Underline the word, it may fail. You may enter into an agreement with your employee that for 5 long years he shall not leave you. If he leaves you, he must be paying so much. Basically, such agreements are not tolerated in the eyes of law. They are treated as agreements in restraint of trade. Remember, there are exceptions to this rule as well. So long as the restraint that you impose is reasonable, agreement in restraint of trade are maintainable. So 2 points to remember. To start with, if your agreement is going to restrain the freedom of trade of anyone, it's not okayed in law. Number 2, when you restrain a person to carry out his freedom of trade, if that restraint is reasonable, the law may tolerate this. Remember this, the rest you can go through. And the next important one is restraint of legal proceedings. Law again discourages one's freedom to approach the courts of law for the enforcement of their rights. It's your agreement restraining a person to approach the court of law is invalid. Such an agreement does not mature into contract. So you should be careful of that. However, very important thing you must note is that if by restraining others' freedom to go to court of law, you have created alternative forum like arbitration. If you agree with your business partner that if there is any dispute among yourselves, you will not go to court of law, but you will refer it to arbitration, then such agreement is valid. Further, partial restriction is valid. You may not stop the other person's freedom to go to court of law. You may decide the jurisdiction. That is the most common thing which businessman does. The disputes are subject to Hubli jurisdiction, subject to the courts at Hubli, and so on, are valid. Okay, so partial restriction is valid. And going further, the obvious things are if there are uncertain events, agreement. If there are uncertain events depending on which your obligation is enforced, agreement may become void. Wagering agreements, the object of the agreement related to wagering like gambling, subject to some exceptions, agreement is void. Of course, obvious thing, agreement to do impossible acts, known to the parties, unknown to the parties. If they had agreed to do something by itself impossible of performance, the agreement fails. It's the quick overview of void agreements. Remember the list and make sure that your agreement does not belong to any of these categories. I now have come almost to the fag end of this lecture. And how if I take another 10 minutes?
Yes, please continue, sir.
You can
We'll be
continue.
grateful. Please continue, sir.
I don't know why, because the hurry really did not make some of the things to get translated well, is what I'm getting to know. But yet the things that I'm yet to cover are important. Hence, I would take about 10 minutes more.
Yes.
Sure, sir. Sure, sir.
Okay. Yeah, I'll reset my alarm. Okay. Well, there is something called quasi contracts in this Indian Contract Act. Of course, the lawyers would understand there is no word called quasi contracts in Indian Contract Act. It may be for your surprise. All that Indian Contract Act uses is certain relations resembling to those created by contract. It does not use the expression quasi contracts. Quasi contracts is an expression conveniently used by us. So what it means is that sometimes, very strangely, businessmen should know the law imposes a contractual relationship between the parties, even though we never intended to make contract, even though we never knew that we are into contract. There are 5 such circumstances when we may be in a contractual relationship without negotiating, without drafting, without even knowing that we are in contract. That is to serve a greater object. Such situations exist. Let me quickly take you through them. The first and foremost being, which may be a matter of interest for businessman, that though I said minor's agreement is void ab initio, minor is a person incapable of making contract, his agreement never matures into contract. If you have supplied, either knowingly or unknowingly, some items, some things to a minor or to his dependents, which are considered as necessaries, then even though it's not a contract, you will have your successful claim against the minor's property for recovering the value of necessaries supplied. Right? I'll leave at that, and the details you must look into. Secondly, payment by interested person. Very interesting thing. If you know, a person who is interested in the payment which he does not owe but others owe. B owes, let me take this example. Mr. B owes payment to A. B has not paid the money to A. C is not bound to make payment to A, but he is interested in that payment. So on behalf of B, C goes and makes payment to A. Then can C recover it from B? The law imposes a contractual relationship. All that is required is the person who has made payment, though he is not bound to make payment, has paid because he is interested in that payment. Right? Well, I think if I have to take an example for this, what example can I take? Let me take the statutory example itself, a statutory illustration itself. Say a zamindar has leased out his landed property to a lessee for 5 years. Okay? Lessee has enjoyed the landed property for 2 years. In the meantime, government has issued a notice for sale of this zamindar's property because the land revenue is not paid by the zamindar. Is lessee interested in this payment? Lessee is really interested in this payment because if it is sold, lessee will lose his lease for another 3 years. So lessee goes ahead and makes payment to the government. Lessee goes ahead and makes payment of land revenue to the government on behalf of zamindar. Is lessee entitled to receive it from zamindar? The law says yes. In what capacity? As if there was a contract between zamindar and lessee can have a successful claim against zamindar, right? So that was second category. The next one is liability to pay for non-gratuitous acts. If somebody has given some goods to you or done some service to you. He was not intending to do it freely. Then whether you wanted him to do it or not, if you have received those goods or received those services, under a circumstance when you knew that he was not doing it freely, you got a duty to pay for it as if you have entered into a contract. The best example is a salesman comes to your home with some saving machine. He demonstrates, try to convince us you will not get convinced. He will go off. While going off, he forgets one piece and goes off. You start using that. Are you bound to pay for it? The answer is yes. In what capacity? As if you are in a contract, because you know the goods that are let with you are let under a circumstance when the person has not come to give you freely. So you are under an obligation to pay for it. So you must remember. And this is very important, interesting aspect. Finder of lost goods. One must be careful if you find the lost goods on the street. If you happen to find my purse, my wallet that fell on the street, it's open for you to pick it or not. If you pick it, it's interesting to know you come under a legal obligation with me. And the legal obligation is contractual obligation. You will be under a duty to trace me, the real owner. You will be under a duty to return that to me. You will be under a duty not to misuse it. You will be under a duty to take best care of my wallet and return it to me. Okay. So, and your duty is as if you are under a contract of bailment with me, right? You will have those many duties. So that's another instance. And the last one is liability to pay for money paid under mistake or under coercion. Again, if somebody compelled you to pay money, for example, I was telling you, a while ago, VRL, you send some goods to me through VRL from Hubli to Bangalore, you are paid at that place. Somehow VRL made a mistake and they made me to pay as well. I showed the receipt and I told them the consignor has paid the higher charges, but the VRL manager is not agreeing with me. He compelled me to pay once again and I paid it because I wanted to deliver the take the consignment quickly. It was important. Did I pay money in coercion? I did pay money in coercion because he was not willing to return the good to me, return the consignment to me unless I pay it second time. So this is the money paid by me in coercion. I can collect it from VRL manager as if he was contracted to pay it to me. Similarly, I wanted to pay money to X. By mistake, I paid it to Y. Y is under an obligation to return it to me as if he had contracted to return it to me. So there are these 5 instances where the contract is not voluntary and the law imposes upon the parties, right? Well, I think I will skip few of these aspects and straight come to of course, I have 5 more minutes and I'll make judicious use of these 5 more minutes. What bothers the businessman most is having made such contract. If the parties broke the contract, breached the contract, if they did not perform the promise, which in law we call as discharge by breach. Okay? Breach happens when a party renounces his liability under a contract. I have a liability under a contract. I will say, I don't have liability. I will not perform. I am renouncing my liability. When a party by his own act makes the performance impossible, I have agreed to sell my motor car to you and agreed to give delivery of that on the last day of this month, but on 15th I sell it to somebody. I have made myself incapable of performing the promise. Or I have agreed to sell 100 bales of cotton to me. I have agreed to sell 100 bales of cotton to you and I give delivery of only 80 bales. Again, the breach is committed. When the breach is committed, what is the consequence is what we should be looking at. The breach usually happens in 2 ways, and which in law we call anticipatory breach and actual breach. The import of these two kinds of breaches is simple. In the case of anticipatory breach, I am expressing my intention not to perform my promise much before the time for performance arrive. Okay. I have agreed to give delivery of my motor car on the last day of this month, but 20th I'll telephone and say, I'm sorry, I'll not be performing my promise. What have I done? I have committed anticipatory breach of contract. Conversely, on the day when the performance arrives, I'll say I'm not able to perform. Actual breach has happened, right? Why these two kinds of breaches become important is for this reason. If there is an actual breach, remedies for damages or specific relief, as the case may be, would follow, right? If there is an anticipatory breach, the result is interesting. Okay, look at that interesting result. When there is by now you got to know what is an anticipatory breach. Much before the time for performance arrives, party expresses his intention not to perform the contract. That is anticipatory breach. The result is the other party may immediately treat the contract as rescinded, concluded, breached, came to an end, and sue for breach of contract. Okay, when you do so, you are freed from your obligation as well, right? Supposing, if I may have to quickly give the example, I agreed to sell my motor car to you. You have agreed to pay me on 20th of this month, and I have agreed to deliver it on the last day of this month. Fine. On 15th, you will call me and say you will not go with the contract. You have committed the anticipatory breach, isn't it? So I am excused from giving delivery, and I may treat it as concluded, and I can sue you for damages if I can show some loss as a result of that. Matter is very interesting. When the party expresses anticipatory breach, though you have a right to treat the contract as concluded and rescinded, you will not treat it as concluded and rescinded, but you will keep it open. You will keep it live. You want to wait till the day for performance comes. Is that okay? On 20th, you had to perform your promise. On 15th, you will call and say you will not perform your promise. That means you have committed anticipatory breach. I have a right to consider that the contract is concluded, but I will not consider so. I'll keep the contract alive. Then very interesting consequences would follow. One is, party who has committed anticipatory breach may change his mind later. If you have kept your contract alive, party who has committed anticipatory breach may change his mind later, and he may later wish to perform the promise. Then you are bound to accept the performance, and you are not freed from your part of the performance. And nextly, party breaching the contract will be entitled to the benefit of frustration of contract. Look at this very important consequence. If I may take an example and tell you the same example. I had agreed to give delivery of my motor car to you on the last day of this month. You had agreed to pay me on the 20th of this month. On 15th, I committed breach. You have kept the contract alive. As you have kept the contract alive, on 25th, my car is burnt in an accidental fire. Am I excused? Though I have committed the breach on 15th, since you have kept the contract alive, impossibility of performance has happened to me on 25th because my car is burnt in accidental fire. I will be allowed the benefit of frustration, right? So keeping the contract alive comes with that risk. So quickly, I'll end with this slide. Remedies for breach of contract. What remedies a businessman will have against a party breaching the contract? First is damages. Second is specific performance. As a matter of rule, you can claim damages. Damages is a technical term for lawyers. Damages is not plural form of damage. Damages is monetary compensation for the damage caused, that is for the loss caused. And exceptionally, you have specific performance too. As a matter of rule, monetary compensation. As a matter of exception, if the thing that is agreed to be given to you, the thing that is agreed to be done towards you, cannot be equated in terms of money, specific performance become applicable to you. Specific performance is usually available in the case of immobile property, in the case of sale of goods which are not easily available in the market, and so on. Right? Well, specific performance is, of course, to compel the party to perform the very promise itself and no compensation in its place. When you talk of damages, there are two important things involved called remoteness of damage and measure of damages. If I have breached the contract, I am not responsible for every loss that happens to you as a result of my breach. I had promised to give this lecture and start at 11 o'clock. At 10:50, I'll breach my contract and say, I'm sorry, I cannot do it. What are the losses you suffer? Maybe you are eagerly looking forward for joyful lecture, mental agony. Loss of reputation in the eyes of so many people participating. Loss of reputation of the institution. Maybe loss of admissions. Maybe you were unhappy, went home and quarreled with your husband, wife, etc. Maybe you quarreled with your children as well. What not? It goes on. The link goes on. For what I am responsible? I am responsible for the nearer damage. I am not responsible for the damage which is the result of my breach, but which is very far. This is known as remoteness of damage. Okay. So a breaching party will be liable to compensate for the losses which are close to the breach, right? So the courts will decide that. And nextly, measure of damages. How do we equate your loss in terms of money? When we equate the loss in terms of money, it is compensatory and not penal. Indian Contract Act does not intend penalizing the breaching party. Indian Contract Act only intends to compensate the loss caused. I think with that, I will close my discussion, and I really don't know how much of sense that made. However, I would be glad to answer the questions which I really did not, especially on the top points which I really did not clear. I think with this, I hand over the screen to the organizers. Thank you.
Thank you, sir. Thank you so much for your insights and valuable information, sir. With your permission, can I take up the few questions from the participant side, sir?
Yeah, please. That is the only time where we can do good job.
Yes, sir. There are a couple of questions from the participant side. The first question from Chaitra, her question goes like this. If minor is a co-owner of a company, how will he enter to the contract with a third party?
Of a company, co-owner of a company. Okay, in the case of company, question of ownership does not come. As we all know, ownership lies with the company. And first of all, a minor cannot be a shareholder. It's not a valid contract. It's not a valid contract. Yeah.
Thank you for your answer, sir. The next question is from B.V. Bellin Law College. The question is, the certainty and possibility of performance of the contract by the parties need to be expressed, or it is inherent element in a contract. Once again, I'll tell you, sir, the certainty and possibility of performance of the contract by the parties need to be expressed, or is it inherent element in the contract?
He'll ask his question.
Okay, sir. Okay.
Sir, at the outset, it was very fascinating to listen to you. Actually, I wanted to say this, because when a subject that goes close to your heart, I know that time cannot be a constraint. And we are very, and I was knowing that it goes more than 1.5 hours, so I scheduled my appointments like you. So my question is, there are two questions I wanted to ask. One, I was about time. You said about that impossibility of performance of the contract that during COVID one cannot where the supplier could not supply the garments due to lockdown and everything. So the manufacturer cannot plead the defense of impossibility of the contract. But now the question is whether this certainty and the possibility of performance can it be is it the expressive element in a contract deed or can it be inherent? Because we heard of a case that where a music hall was booked that was destroyed because of fire and contract could not be performed. So in the light of that, that question.
Second question.
Second question is with respect to this breach of contract. So breach of contract, the compensation is not penal, you said. Now, suppose, can we relate breach of contract sometimes to a criminal offense? Suppose A abets B to commit a breach of contract that he entered with C. So accordingly, B commits the breach of contract. Now, A and B, A is accused of abatement. Can B be also be accused of abatement? I mean, can be accused of making the breach of contract as a from a criminal law point of view.
Okay. I think I'll take the second question because the answer to the second question is quicker. The criminal law will take course and both of them would be abettors is my understanding. And second thing for the second question only, that is what all I meant was, however condemnable is the act of the breaching party. However condemnable is the act of the breaching party. I wanted to cause loss to your business, so I entered into contract. I knew much before entering into contract, I wanted to break this contract. I knew it. I entered into contract. I made sure that you will not contract with others. You will contract with me and depend on me at the right time in order to cause loss to you. I will break my promise. So ill will, so criminal act. For my ill will and for my criminal act, I will not be punished under contract law. All that the contract wants to do is that, though I have done it with so much ill will, the contract will not, contract law will not look at that ill will part of it. It will look at your loss. Though I have done such a thing, if there is no loss that you can show to the court, you will go with no compensation. I will go with no punishment. Okay, coming to the second, first question, which I said I'll take second. This is very interesting question. This is force majeure versus impossibility of performance. All that you should, those two examples I took in the beginning. For those two examples, we will connect it with force majeure and not with impossibility of performance. Impossibility of performance should not be expressed in the contract itself. If the impossibility of performance happens, whether you have expressed it or not, you can have the benefit of impossibility of performance and get rid of the contract by showing that performance has become impossible for a variety of reasons, either for later occurrences or for change of law and for the reasons that we know. Whereas, when it comes to force majeure part of it, we must contemplate and we must include widely expressed language in the contract. Coming to the instances, I spoke COVID-19 instances. Had we include, because in those two examples I gave you, impossibility of performance did not occur. Difficulty of performance has occurred. Difficulty of performance has occurred. The difficulty needs to be actually condoned, but the parties may not do it. Had they incorporated force majeure clause, it would have been possible for a party who has to perform his obligation to ask as a matter of right the extra time and so on. So that's where it is force majeure clause versus impossibility of performance. Again, to repeat, force majeure clause must find its place expressly in the contractual document, whereas impossibility of performance need not be there in the, need not be expressed in the contract. By the application of law of contract, you will, I think it is section 56, you will avail the benefit.
Okay.
Did I answer the question?
Yeah.
Thank you, sir.
Yeah.
The next question is from our student. Her question is, scope of oral contract in a business transaction and how to meet the contractual requirements there.
Scope, right? What is it?
Scope of oral contracts
Okay. Hmm.
in a business transaction, how to meet the contractual requirement there.
Okay. I think I understand the situation is, as I already told you, oral contract is perfectly valid, enforceable contract, as valid as written law.
Yes.
But in the same breath, I told you, if you can prove, proving oral, of course, I'm not saying proving oral contract is not impossible, it is difficult. When you take the task of proving oral contract, difficult task of proving oral contract, there are no special requirements. Whatever requirements that are to be present, an agreement to make a contract, as I said, same thing hold good, but there is a difficulty. There is not impossibility. If you ask me, how do I address that difficulty? Difficulty has to be addressed by adducing evidences, witnesses, and conduct of the parties. So I repeat, it's difficult, but not impossible. Requirements remain the same.
Yes, sir. Very well said. If you permit, I'll take two more questions, sir.
Go ahead, please go ahead.
Okay. The question is from our student. In case of anticipatory breach, where the contract is kept open and live, the party responsible to perform an act refuses to perform on the day on which he expected to perform, what is the remedy?
Anticipatory breach.
Breach where the contract is a key open and live and the party responsible to perform an act refuses to perform on the day which he expected to perform, what is the remedy?
Okay. Yes, the question is well, asked. There is no doubt about it. When anticipatory breach is committed by X, Y has an option to treat the contract as concluded on that day or wait till the performance arrives. The question is that Y has waited till the day for performance arrives. On the day of performance also, the person committed anticipatory breach again did not perform. Is the question. What is the remedy? Remedy is this, that again you will sue for damages, and probably the question is damages has occurred on the day of performance or damages has occurred when the anticipatory breach was announced. Probably this is the question. This should be the question.
Yes.
So the answer to the question is, even though anticipatory breach was committed earlier, since you kept the contract open, you waited till the day of performance, you are allowed to show the loss that is caused to you on the day of performance and not on the day of anticipatory breach. So the loss will be calculated as it existed on the day of performance when it is refused and not on the day when anticipatory breach is committed.
Thank you, sir. Thank you for your answer. The last question is, what is the consequences of fundamental breach on the business transaction if any force majeure event occurs?
Okay. Force majeure event also will not save you from fundamental breach. Force majeure event enable you some temporary limited excuse. And fundamental breach, if your term, if you have committed fundamental breach of the contract, even the force majeure situation will not save you. What will save, as we discussed a while ago with Jessima sir, what will save one from fundamental breach is only frustration and impossibility of performance and not the force majeure clause.
Thank you, sir. Thank you for your answer. And the last question is, how this pandemic situation has helped the convenience of e-contract to emerge? What are the laws are protecting the e-contract in business transactions?
Okay. So as the answer is hidden in the question, pandemic days have enhanced the e-transactions and e-contracts, and e-contracts are on the growth, are on the growing. And what are the laws that affect the same Indian Contract Act? Okay, and all laws bearing on contractual transactions coupled with Information Technology Act. Information Technology, yeah, Information
Yeah.
Technology Act. That's it. Yes.
Okay.
Sir,
Thank you.
I have one doubt, sir.
Please go ahead.
Not at all doubt, but see, in the emphatic term that contract is an asset. Really, now after listening to your lecture, I realized really it is an asset. It is kind of orientation for all of us.
Yeah,
And at the beginning,
it was
actually,
great
you stated about,
yeah, it was great learning
sir.
experience for me to
Yes,
line. In fact, it's very
yes,
valuable.
yes, sir.
Contracts are
Yes.
very valuable assets.
True, sir. And you have given about the kind of information about the importance of contract management, drafting about the contract, and kind of illustration about the basic fundamentals of the contract. I want to just know about interpretation of the contract. So kind of, is there any principles regarding interpretation of the contract, like how in interpretation of statutes court adopted like that here? Is there any principles or any doctrines whether court has recognized or determined while interpreting any contract? So can you put little light on this, sir?
Yeah, of course. That's very interesting. That's very interesting aspect. The law, the rules of statutory interpretation by and large are applied, and gathering the what the parties have desired, that has to be kept in mind. The first basic, of course, I cannot avoid using this jargon. That is, first basic principle of interpretation of statutes is seeking the intention of the legislature.
Intention.
Similarly, at all times, first basic feature, first basic rule of interpretation of a contract should always be to see the document, contractual document, holistically and understand what exactly the parties have desired, right? And sometimes go with literal construction, sometimes go with purposive construction, right?
Sir, thank you very much. If it is possible, please share your PPTs. PPTs were also very nice, sir. Thank
Right
you.
away, right away, I'll
Yeah.
share this.
Yeah.
So much I could not explain. My slides
Yeah.
could explain is what I fondly hope.
Yes, sir. Thank
I think there is one more question Sunita has skipped because she is also a IP practitioner, the person who raised that question.
Pleasure. Go ahead.
Question is non-compete clause a restraint of trade? That is what is our question is. It is asked by Zahida Mullah. She is a practitioner based in Bangalore, sir. Is non-compete clause a restraint of trade?
Non-compete clause?
Yeah.
Okay. Answer is yes and no.
Okay.
Answer is yes and no because as I told you already, to start with, non-competing clause is technically, logically in restraint of trade of another. As a result, it is bad and wide. However, there are exceptions to this rule. That is, if it is a reasonable, non-competing clause is valid. For example, if there are two grocery merchants, one next to other, I enter into agreement with my neighbor grocery merchant. He agrees with me to shut his business so that all customers will come to me. And he agrees not to carry on grocery business for his lifetime anywhere on the earth. This agreement is wrong. This agreement is bad. Suppose the agreement between us provided that he will not open up grocery shop in the locality or within a radius of 5 kilometers for 5 long years, then and only then this non-competing agreement is valid because it's reasonable.
I have a last question.
Yeah, please go ahead. Pleasure.
Now we are in the era of technology and smart contracts are coming up. The smart contracts covered under this law of contract.
Yeah, indeed. Indeed.
There is, I think, a dispute between academicians wherein some say that they are legal, smart contracts are legal. Some say that smart contracts are not legal. They are just procedural aspects that are determined by the computers through programs.
I'm sorry. Can you throw light on what do you mean by small contracts?
Smart contracts are
smart contracts.
Yeah, smart contracts. They are the contracts which are drafted by computers, sir, in order to execute actually the main contract. Yeah, so exhaustive that they may be main contracts as well. So it is very difficult to determine whether they are contracts which are valid under the contract law or not. So there is division of opinion saying that they are contract under valid contracts or not. So what is your take on this? Because they are drafted by computers, executed by computers in order to comply the conditions between the two persons who are doing some transaction.
Okay. That, in my view, squarely fall under the category of contracts, namely unilateral contracts, which I named them as standard form contracts. Okay. The law I was explaining about standard form contracts on what are all the grounds on which you can nullify the draconian terms that are imposed by one party over the other. This law, though judge-made law, is developed by interpretation of the kind of acceptance that is given by the parties. As such, it is part and parcel of Indian Contract Act. And the let's call it a contract, let's call it standard form contract, and let us be ready to use the protective devices the courts have evolved to protect the interests of weaker party against the stronger party who dictates the terms through computer generated contracts. I am of the firm belief that it is a contract, it falls within the ambit of law of contract.
Technology is overtaking us so much that there may be contracts entered into between things, not between persons.
Correct.
Now Internet of Things have come in, and these things may enter into contract with each other. So they also may come within the purview of law of contract. They will be enforced under the law of contract.
They do.
Owners of those things.
They do, no, because these things are controlled by men.
Yeah.
These things are controlled by men.
But contracts are entered into between the things, by the things.
Those things are tools. Those things are not persons, they are tools, they are my tools. I don't bargain with you, I don't draft it, I let it to my computer, but I'm the controller of it. That's my tool.
Because the main program is in the hands of the human beings only.
Even if it is the robot which makes contract for me using AI, yet the AI technology, robot, is my agent. I would rather bring in law of agency, isn't it? I am bound by the contracts made by those things.
Correct.
Persons were agents, now things are agents for me.
Yes. Thank you. Thank you so much.
Thank you, sir, for your wonderful lecture and patience answering for all the questions. And I also extend my sincere thanks to our principal madam for giving me this opportunity and made me to be a moderator for this session. I think student got privileged to take a knowledge shared by you, sir. We expect more informative session in future also. Thank you, sir. Now I request the Sulabh to take over the session.
Thank you, ma'am. Thank you, sir. Now I request our beloved principal of K.L.E College, Srimati Dr. Shardaji Patil, ma'am, to deliver the presidential remarks. Over to you, ma'am.
I think we have to skip this. Let us go for vote of thanks.
Yes, ma'am.
Anything I cannot comment on sir's lecture. Actually, it was wonderful speech, but only the thing is, what I can say is, I must wholehearted thanks to you, sir.